Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. Yes, this is a breaking news development in the case involving Young Thug, Judge Glanville, Miss Bumpus, Miss Kayla Bumpus, and District Attorney Adrian Love, as well as Brian Still and Mr. Weinstein. So there are a few plays that we're going to be talking about today. And for those who don't know, just came down the pipeline, just came out from Judge Krause's chambers. She has recused Judge Ural Glanville from presiding over anything pertaining to YSL trial. So what does that mean? Well, before I tell you what that really means, I'm going to bring in the legal analyst, a veteran of law for over 20 plus years, a college professor, a former prosecutor in New York, as well as she's a cool host. Without any further ado, I want to bring up attorney Aikisha Al-Shabazz.
What's up, Dennis? What's going on?
Let me get that $5 out of my pocket. I want
to run me my bread.
Before I do that, I think there's also outstanding. Okay, we'll leave that there for right now.
Whatever. Listen, that's not outstanding. Listen, you're gonna owe me that money too.
Listen, I forgot
that issue has not been decided.
It hasn't been decided yet.
It has not. When it comes down, you're gonna be running me some more bread. Let's say hi to the people that's here.
I think
hey Angela, hey, be more shorty. He don't like to say hi to folks. Let me say hi.
How everybody? How everybody?
Sea Breeze, Hershey, Too Thick, Purple Passion.
We're gonna get to the shout outs in a minute. We'll get to the shout outs in a minute. That's listen, hit those. You know what to hit. You know
hit the like and subscribe.
We're gonna have a bunch of questions, ladies and gentlemen. But we got the exclusive. It's not so exclusive anymore. Hit the docket already, but we have the judge's order, and we're going to go into the judge's order. But before we do that, did you? Well, I know you want to bet, but did you think, based on reading this order, that
I didn't finish? We reading it in real time, people. I just opened it. How would you thought?
Okay.
We're reading it in real time, and so I will react to it in real time.
Oh my goodness! So
let's do it. Listen, it's nothing like the
Listen, ladies and gentlemen, this is. But before we read it, I want to say this. There's been a lot happening in the last couple of days, last 24 hours, last 48 hours, and it's so much that we have to discuss. I mean, it's just the news cycle is just keep giving. We got an assassination attempt. We lost some very cool people over the weekend. And it's just a lot going on. And we're going to go into that, but let's talk about why we're here. We're talking about the YSL trial and why I think it's dead in the water. Without any further ado, ladies and gentlemen, let's bring up this order. We're going to read it together. Let's go. Ernie, let's go. Let's see what this judge has to say. I think she kind of was soft shoeing. I read it, but I want you to read it.
Okay. All right. Here we go, family. This is the order. And it starts off, order and motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including, remember, it wasn't just one defendant that tried to get him removed. It was multiple defendants. So the first motion that she considered was the defendant Diamante Kendrick's motion to recuse Chief Judge Ural Glanville, filed on June 12, 2024. 2, Kayla Bumpus' motion to quash. Remember, Judge Glanville had put out what's called an order to show cause, which is an emergency order ordering persons to appear before him to find out who leaked the information about the secret meeting. So that's number 2, Kayla Bumpus' motion to quash, not squash. So let's get that clear right here. It is quash, Quash. Don't listen to other legal channels saying squash. If you hear somebody say squash, click off that shit quick, because they don't know what they're talking about. That's some scary stuff. All right. So 3, defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville from all further dealings in the above reference case and amended supplement. Remember, in addition to the motion, he then filed a supplemental motion. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. The legal landscape has changed significantly right? That we have judges referring to social media.
Let me say this, attorney.
Go
10
ahead.
years ago, I had a judge in the same courthouse that said, "Well, we can't use the video
Right.
while it may look nice and framed well, but we have to use the transcript from the our court reporter." Well, court reporter is a new day. Let's go.
Right. It's a new day. It is. And they're gonna be fighting for their money because they get paid by the page.
Right.
All right. That's an aside. All right. Having considered the record evidence and applicable case law, the court finds as follows. Findings of fact. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Kendrick, these are citations. I'm going to skip the citations unless it's relevant. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th, 2024. The motion to recuse all arise from the same circumstances related to state's witness Kenneth Copeland, a.k.a.
Lil Woody.
Lil Woody. Come on, that was your
Lil
plug.
Woody.
Come on, you ain't on point today.
Lil
All right.
Woody.
Little
Well,
Woody.
Counsel,
It doesn't say Little Woody in the order. That's why we want to make
Woody.
sure you know who we're talking about.
You can enlarge this document on your end because it's not on my side. So if you want to zoom it in, you have a plus sign above the document, so you can do it 200% if you want.
Let me see. Let me see.
Hit it one more time for those
One more time for the blind folk.
Yeah, one more time. Hit it one more time.
One more time? One more game?
That's good. That's good.
200. You want 200?
Yeah, 200 is good.
Forgot you was blind in one eye.
Okay. Next page. What page are you on?
I am. I got to do the pages too.
Yeah. Well, no. Click the page. I can't move it. You have to go.
Oh, I got. Yeah, I'm doing everything today.
Right. Yeah.
Okay. All right. So I'll read from the document then. I was reading from my phone.
You don't have to.
No. Okay. On January 7th, so we ended here with state witness Kenneth Copeland. On January 7th, 2024, the state intended to call Kenneth Copeland to testify. Now, I'm not going to run down to footnote 3 because that's how you typically would read it, right? So you see where it says footnote 3, you have to go down and see Khalif Adams' case was severed, and though he is not currently on trial, his case was transferred to this court because Caleb Bumpus' motion to recuse Judge Glanville in association with the show cause and contempt issue was filed in Mr. Adams's portion of the docket. So that we don't always have to read footnotes, but we should not assume they're not important. All right. Prior to this testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After the discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, 2024, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m., and court was adjourned for the day. On June 10th, 2024 at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Caleb Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for trial defendants did not participate in the meeting and were not aware that the meeting was taking place. I'm sorry if I'm putting the inflections, but that's how I read. Leave me that alone.
Right. Inflections are good.
Yeah, okay. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allowing Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state, who had joined the meeting. Let me just. 2 investigators from the DA's office and multiple deputies were also present. This is the footnote, as well as one or more members of Judge Glanville's staff, including his court reporter, who took down the conference, and I'm sure the dog was there. No, it doesn't say that. I'm sorry.
I'm
All
soundboard
right.
today.
During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all the defendants in this case, not just the 6 currently on trial. Judge Glanville discussed OCGA Section 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his standing counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, Defendant Williams' lawyer, Brian Still, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting. Ex parte means one-sided, meaning only the state was present, only representatives of the state. And this is an adversary proceeding, so that's what he means. That's what ex parte means, that the other side wasn't there. He objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams. Ultimately, Kenneth Copeland did testify on June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st, 2024 for an in-camera review of the transcript. In-camera means in the chambers of the court, not in the actual courtroom, where only the judge is going to be looking at the transcript, right? So an in-camera or whoever comes into the in-camera session can see the transcript. For an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by DeMonte Kendrick on June 12th. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 12, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review, contains assertions of facts that support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. The way she wrote that is incredulous, right? I don't know if you can. I don't know if I'm conveying her sense of incredulousness. She's like, motherfucker. And she's quoting him like, you said. All right, that's just me. On June 14, 2024, Kayla Bumpus then filed a motion to quash the show cause order and or recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus, resulting from alleged disclosure of the ex parte meeting. On June 17, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole, Mr. Williams's motion and supplement also seeks to recuse Judge Glanville because of his involvement in the ex parte meeting. So she's attacking Brian Steele's motion. She's basically saying you are exaggerating, right? You're a bit hyperbolic. That's what hyperbole means.
Yeah.
You're exaggerating.
She's providing cover for Judge Glanville,
right? But at the same time,
some may think that he wasn't being hyperbolic. Some may believe that.
Yeah, some people may. But she is. It seems like she's deciding to call it out and sort of ignore it, right? So divorce from its hyperbole, Mr. Williams's motion, huh?
No, I agree with you.
Yeah. Mr. Williams's motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams's motion, and I'll come back to that footnote, alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process where he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. Mr. Steele's counsel moved to recuse Judge Glanville for further handling the conduct. I just want to check to make sure we ain't missing nothing in the footnote. However, that motion was made orally and is not before the court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Although reference to this court for consideration, Bumpus' motion to recuse is both premature and moot because Ms. Bumpus has not yet been held in contempt, and because on July 1st, Judge Glanville canceled the show court order. Right?
Hold on. Before you do anything, we have another guest joining us, ladies and gentlemen.
Okay.
We have another lawyer joining us, ladies and gentlemen.
Okay.
I can't take this, but I'm gonna take both of this. I'm gonna be right in the middle of the two of them. So, ladies and gentlemen, let me present the incredible Thelma Anderson. What's going on, Thelma?
What's going on? What's up, sister-in-law?
I'm good. How y'all doing on this good legal day?
Oh, it's a lot happening.
It's a lot.
I'm just trying to keep my head above water because, baby, it's a lot.
I'm planning my exit plan because this is not.
What you talking about? Exit plan? It's only what 2% of us. You can't leave.
Oh, you're right.
You can't leave. You can't leave. We
Now
need
that you
you.
say that.
No. Let's get those points up
more
first.
people.
Let's get to 50%, then you could leave.
Right.
Okay.
At least.
Hang around.
Okay.
So Thelma, can you see the document pretty clearly?
Uh-huh.
Okay. All right.
Good.
So if you get tired, we bring the other lawyer in. You know,
we're on page 6. I mean, you want to take over? You want whatever y'all, but I'm not gonna have to move it. So let me just keep doing it this way because I have to move it. Yeah.
Let's finish and talk about it.
Okay. Let's go. All right. On July 1, 2024, the day appointed for the parties to review a redacted transcript of the ex-party meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex-party meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex-party meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex-party meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained that the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. That was pretextual, if you ask me. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex-party meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex-party nature of the meeting. Judge Glanville also questioned defendant's right to be present at the ex-party meeting because the issue under discussion was between the state and the witness who was represented by counsel. After making this
the tactical advantage is pretty much what he provided tactical advantage to the prosecution.
All right, let's see what the judge says about that.
Okay.
After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. Legal framework. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for belief that biased, who is calling me? I can't talk right now. And reasons for the belief that bias or prejudice exists. USCR 25.1, 25.2. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice toward the moving party in particular, or a systematic pattern of prejudicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. And she cites, bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, For example, the motion is timely, supported by an affidavit, and facts alleged might warrant recusal. Another judge shall means must. Another judge shall be assigned to hear the motion to recuse. Understand, shall is what we call mandatory language. It is not what is the opposite is permissive language, which is like may, right? Another judge may be assigned. Shall means must, meaning that the judge doesn't have the discretion if all the criteria are met. And we all know that Judge Glanville, he announced that all the criteria are met, or at least some of them, and basically was like denied. Right.
The first two, he announced it.
So when considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or other interested parties.
Can you slow up the reading? So they asked to slow it up a little bit. You're reading because
you
know.
Don't try to read along. I don't know it. I'm reading this for the first time, like everybody else. All right.
Yeah. Okay.
And I will not read slower. God damn it, because I'm a product of public school, and then they taught me to read fast.
Oh, that's
just follow along. You ain't got to try to read with me, because this is not going to be familiar if you're not an attorney. This is not going to be familiar with you. Okay. Plus we want to get through it, and it's 2 more pages, right? So 2 more pages, and we will put this out. We'll tweet it out so you can read it for yourself. But I want to get through it so we could talk about it. All right. So this is page 8.
That part.
If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must, see that must? You remember the must? Must refer the motion for reassignment and may not oppose the motion. Bang, bang. Not. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for motherfucking recusal. Goddamn. Woo-hoo, I like it. I like it. A judge had no interest in sitting. I'm reading slower. You see that? A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. Absolutely. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. Ooh, what are we talking about? Vestiges of a motion to recuse. What happens after that motion? We're talking about the stink in the air, right? That's what they're talking about. Like after it's recused, you're going to feel some kind of way because I just said you weren't fair as the lawyer. The judge is going to feel some kind of way about that. And then I'm going to feel some kind of way that you didn't recuse yourself when you should have, right? And so that's going to linger in the air. That's what that antipathy. All right, moving on to the next thing. Analysis and discussion. What is that? Let me close this. Sorry, guys.
The analysis and discussion.
Analysis and discussion is one. It's going to be 2 pages, 9 and 10. I mean, damn. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the 3rd criteria was satisfied, i.e. that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally, here we go with the bullshit, generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, that's the cover. She didn't even need to say that.
Right, that's the
However,
cover.
In his order denying defendant Kendrick's motion, and in the process of making his record on July 1st, this is where he ran afoul. He decided that shit, which made him a party. July 1st, 2024, Judge Glanville added facts, provided context, questioned the the veracity of the allegations and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. God damn. This court has no doubt that Judge Glanville can and would continue to preside fairly. Stop kissing his ass.
Oh my goodness.
Preside fairly over this matter if the recusal motions were denied.
Give
But
this judge
the
some knee
necessity
pads.
of preserving the public's confidence. I think I've said this on so many different lives. The necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Based on the foregoing, this court hereby, she could have tore his ass up. This court hereby orders: 1, defendant DeMonte Kendrick's motion to recuse Chief Justice Ural Glanville is granted. 2, Caleb Bumpus' motion to quash the show cause order and/or recuse Judge Glanville is denied as moot. Moot meaning it's not an issue anymore. All right, so I don't have to decide it. So it's denied because it's not really an issue. Defendant Jeffrey Williams' motion to disqualify recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted.
That's it.
Lastly, the clerk of the court shall reassign this case using the court case assignment procedures. Signed, the Honorable Rachel Krause, Fulton County Superior Court.
Okay, let's get into some things here.
Baby.
Let's talk about this here. First and foremost, hold on. Let me get up here in the middle. I don't want to be right here. Put me in the center here. Okay, let's talk about this. First of all, like you said, Attorney Ike, that judge was being very nice with this judge. You don't need to provide cover if you're going to grant the defense motions to recuse. You got to call it what you got to call the balls as you see them.
Balls and strikes. That's her friend. But that's her friend.
Yeah, but
that's her friend.
While she's still trying to do the right thing,
yeah,
some will perceive that order as, while it helps the defendant, it also helps the judge.
Yeah,
and that judge should have never been a part of that ex parte without having the defense in the room.
So let me just say that. Let's start there, because I agree with her on that. I'm not. Thelma, what's your position on the ex parte? Because it's Georgia, and I'm not sure if they do things differently in Georgia.
I think they do things different in Georgia because Texas, that wouldn't have happened in Texas on any day of the week. So I do
for no reason at all.
No reason. So I think they do things a little different, and I think they were using their argument under a different context to try to get around the ex parte legal issue. Mm-hmm. So I think that's where they were going. However, when it came out, and even her statements about him, I ultimately think she's protecting him from any judicial complaints that can come from this. Mm-hmm. So with her placing that in there, if he was to go before the judiciary, they would look at her statements and saying, oh, she didn't find that he, ultimately, even though she don't think he ultimately did anything substantially wrong. However, the law is the law, and we have to follow the law.
To your point, let me just ask you this question. Mm-hmm. To your point, either one you can answer, can another, if it is referred to the JCC, the body that looks at judges' behavior, can another judge say, well, she got that wrong, or not? Somebody from the body?
Sure. I mean, they tend to give deference, right? Yeah. So this is about setting up a something for them, a springboard for them to go off of, right? And so she's sort of laying a little bit of groundwork to soften any type of blow that might come, right? But independent of that, let me just say, I didn't find anything legally inappropriate with the ex parte meeting, except for the fact that the defense were not told about it. Right now, I have been I've been one case in particular. I was in the middle of a murder trial, right? And there were no witnesses to this particular homicide until like the eve of trial. And at the eve of trial, the prosecutor's like, we have an emergency witness who was uncooperative. And they asked for an ex parte, not hearing, but basically an ex parte conversation so that they could examine. This happened to me in state court. This has happened to me in federal court. All right. Because those are the things that happen ex parte. So it's not inappropriate for prosecutors to have an ex parte meeting with the court when it comes to a witness who is uncooperative and may need immunity, because that has to be explained to them. Usually their attorney is present. Then you are informed about all of the details. You get the transcripts but you typically you're aware that the meeting has happened. You're just not allowed in, right? And the one that happened in state court, they actually did it in the courtroom and locked me out. Yes, they locked me out. Locked me out the courtroom, right? And had this ex parte proceeding. So just for the record, I got an acquittal, full acquittal. Judge was pissed off and ran off the bench and left my client. Yeah, it was a disaster, but it happened. So I agree with her that it wasn't necessarily inappropriate, but I think all of the surrounding circumstances and how he handled the motion was. So Kevin brought up a good point, because that was the other thing Dennis and I were talking about before we got on the live. I was like, there are two things that need to happen now. First, Steele needs to hit them with a writ, right? They're not fuck a motion for bail. He needs a writ for bail. This is an emergency at this point. This guy is sitting in jail and there is no judge assigned to his case.
And they screwed the case up.
Not only did they screw the case up, but it's nowhere near being over.
Right.
It's nowhere near being over. And having him sit in jail all this time is absolutely unjust.
And how can they even move forward with this jury seated and present a new judge, and this evidence that was allowed in by the judge shouldn't have been in? They heard they get Woody's testimony.
I don't know how they're going to do that. I don't know how a new judge is going to come in and view Woody's because Woody is still on direct, right? Did he finish his direct even?
No,
he didn't finish his direct. Right. So this is a shit show. It's really bad.
I think
it was assigned to a new
going to happen.
Okay, listen, ladies and gentlemen. It was assigned to a new judge. While we on this live, someone give me the name of the judge. I can give you the background on that judge. Give me the name of the judge. It was just assigned according to DJ Poppy. It was just assigned.
But I still
tell us who the judge is, DJ Poppy. He's still on direct. That's what I'm saying. So
yeah, he's still on direct.
This is going to be interesting.
If he files even if he files a writ, I think it's appropriate to at least put him on house arrest.
Yeah, well, that's what the writ is, to get him bail.
On house arrest or from an ankle monitor.
I don't think
he's not going anywhere. I mean,
I think we don't know. Young Thug has a lot of resources.
I'll take his passport. I mean, there's a lot of ways that you make sure somebody doesn't move. You make them surrender their passport. So now, that's one way.
But you know what I've noticed? I've noticed that judges are ordering more house arrest at a larger rate than I've ever seen before. And I'm trying to understand, what is the purpose with some of these issuings of
that? I don't see that trend. That's not trending in New York.
Yeah, but I see the purpose is it's overcrowding jails.
That absolutely.
Yeah,
and if they're not a threat,
And Project 2025.
Okay, so here's the thing. Gunner, who was also
all right, Judge Shakura L. Ingram.
I know Judge Ingram.
Judge, that sounds like a black woman, is it?
Judge Ingram. Shakura, Judge Ingram, she's not a black woman. She's not. She's white. She's a white judge.
Shakura?
Yes.
SHUKURA. Where's she from? How you get that name, lady?
hold on a second. Judge
I've
Ingram.
seen a judge.
She's beautiful. Yes, she's African American. Thank you, B More Shorty. This dude right here, over here posturing. I know
Not
who
you
it
trying
is.
to discredit
I know
our-
Judge
No,
Ingram.
I'm thinking about
Not you
another
trying to
judge.
discredit our 2%.
No, hold on.
Exactly. We can't have that, Dennis.
Hold on, I'm typing my Rule 22 right now. Stand by.
You know where to send it? You know what, Judge? Because I don't
I
know.
was listening to the white judge. Oh, Judge Ingram. Oh no, not Judge Ingram. Okay. Oh my goodness.
Okay, Judge Shakura Ingram. I don't know anything about her, but I can tell you one thing about black female judges: they not with the shits. They not with the shits.
Oh, no.
They just not. They not with the shits because it's even less of them than it is of us.
Yeah.
Like I don't even know what percentage it is, but it's probably less than the 2% of us that are in the field.
And they don't play no pissing matches.
No,
they do not.
And there ain't gonna be no favoritism. And she knows that this case is gonna be watched.
I'm ready to see.
I'm ready.
Yeah. I'm ready to see the neck designs that she gonna put on that robe.
She's one of those. She's like
oh my
RBG.
I hope so. That? That's what I'm saying. Like,
okay.
Give it to us.
And
give us a good beat down. You know?
Ruth Bader Ginsburg was known for the collars that she wore in the Supreme Court. So
I gotta make a call, guys. I gotta put this on mute. I put this on mute, but keep talking, please.
That is awesome. All right. Well, when are they back to? She's Hilton Sora, beautiful judge. What is Hilton? AKA? What are they? We learning in the chat because I don't know. I'm gonna say they could. No, I ain't gonna say nothing. Let me not say nothing.
I'm excited. I'm like,
yeah. Delta, even better. I said that out loud. Sorry, AKAs. Listen, my aunt is a Delta. I grew up with Deltas, and I lean Delta. So y'all gonna be mad if you won't. So that's good. All right, so that's interesting. It'll be interesting to see how she deals with the previous rulings on Little Woody's direct examination, whether she's going to continue to allow them to play these videos, which first of all, Hilton, what's her name? Hilton, her argument for getting these videos in, I didn't understand how the defense didn't attack that. They were like, oh, this is supposed to be, what was her basis? A 621 argument?
Yeah, she's a relatively new judge there. She's been on the bench for about 7 years.
That's not new.
That's not new.
That is not new. You just said 7 months.
She didn't.
Well, yeah, judge.
She didn't been through one. She almost through her second term.
Yeah, she should be at the point where she's operating without fear or favor.
Okay. Well,
she's done it enough that she has confidence in her decisions, because sometimes new judges, and I've seen this. I listen, I've been practicing for a long time. I feel like I've done a little of everything, but I tried a case in front of a judge. It was her first trial. And I promise you, every goddamn ruling, she was like, 1 second. She was calling someone to make sure, like, they saying sustained. I'll be like, hold on, what the fuck is going on? So 7 years, she doesn't need to call anyone anymore.
So it's interesting that the first judge that was assigned the motion hearing, she recused herself and then went to Judge Krause. Now it's back to Judge Ellaby. It's only a handful of black judges in Fulton County.
That's crazy because it's Fulton County.
Yeah, it's only a handful.
What's the population? What's the population makeup of Fulton County? What percentage of it is black?
In Fulton County?
Somebody Google that.
Yeah, Google that. Yeah, I don't know the stats on that, but
what's the percentage of black people in Fulton County? What is it? 70%? 60%? Is it more? Is it less?
Let's talk about this case and how financially cost ineffective it would be to re-prosecute. And do you think the prosecutors would agree to just dismiss this case?
No. Absolutely not. However, they might not oppose a defense motion to dismiss. They wouldn't agree, right? Because There are instances where a prosecutor understands that the case should be dismissed. Either maybe it's old or they have an uncooperative prosecutor, but they want to save face, right? So they don't want to be the ones to dismiss it. I have had conversations with the prosecutors to say, 30-30 is your friend. That's our speedy trial statute, which means that just let it run itself out, right? For those cases, because they don't want to outright dismiss them. So let it time out, or let me file what's called a Clayton motion in New York, which is a motion to dismiss in the interest of justice. And you just don't oppose it. Don't oppose my shit, right? And then the judge is like, oh, I got an unopposed motion here. I got to grant that.
Here's the other part. Brian's attorney Brian Still also requested to have the prosecutors recused as well. He filed a motion for that.
Thank you, D.
Judge Krause didn't address that, Attorney Shabazz.
In their motion, they had to recuse the prosecutors?
Yes.
You sure? You saw it? Because you like to talk secondhand.
No, I saw it.
Okay, well, I didn't see it. So until I can see it in the motion, I'm not going to speak on it because I don't know, how that happened. Okay, D, thank you, D. Love you, D. 42% black. Okay, that makes sense then. I thought it was more black people in Fulton County. What the hell?
Someone said 70% black. Fulton County's not.
Oh, come on.
County's not 7% black.
Love will absolutely not give in to nothing. I agree, Doc. She's not. She's like, this is personal for her at this point.
Yeah, but the problem is it's costing the county too much money to have this. Now that's
wow. Be More Shorty says that Ingram just was reelected, which you know what? The beauty of that is she ain't going nowhere.
Right.
And she doesn't have to worry about an election.
But she was I don't think she had a candidate that was trying to oppose her either. Most of these judges just, they go on to the next term unless it's someone wants to challenge her. The only one that got challenged was Judge McAfee. That's the only one that was challenged. The only one was challenged, and he won.
So I mean, I feel like McAfee caved because the election was on his ass.
Yeah.
We don't have this same sort of issue with this judge,
no.
Right? The election's already over. She's in, and she doesn't have to run again for what's the appointment? 4-6 years?
It's 6 years, I thought.
I don't know, 5 years, whatever, something. But she's in. She's good. So she should be able to decide this without fear or favor, which is what they're supposed to do.
Yeah. This is one thing that I've recently been talking about with colleagues is
politic. I didn't know that.
We're getting to a point where I believe at some point they're going to have to discuss removing immunity from judges and prosecutors for either judicial misconduct or prosecutorial misconduct.
Yeah.
Because until you remove that shield of protection, they feel untouchable. And they feel like they can do whatever they want to do because they got that layer of protection of immunity, just like police officers.
Right.
However, when you are taking someone's liberty away, it is so easy to lock them up. It is so hard to undo the injustice when it's highlighted, when is brought to the attention of the court. They don't go in and say, oh, yeah, this was done wrong. No, it's a whole long, drawn-out process.
Yeah.
Let me ask you guys a question. Judge Glanville was recused from this presiding over this docket. So he can't preside over all these cases were severed. Can they assign of those cases that were severed? How's that look? It's the same docket, isn't it? Or is that a different docket?
I don't think so, but it probably at this point, I don't think the other defendants have any bearing to do with this particular recusal.
Yeah.
I think it only affects these defendants.
He had made some decisions early on with these defendants that have been severed from this particular case.
Yeah, it's not going to undo anything he already did.
Okay.
Right? But going forward, he can't have any more to do with this particular case, the one that's on trial now. Those 6 defendants that are on trial.
But it's still the same. Still signed.
So what?
Okay.
It's okay. The severance is the severance, which means they're going to have a different jury. They're going to have different evidence. They're going to have different different prosecutors. Could be a totally different trial, right? So the problem is, though, he already appears, right, to be unfair. And so it is unlikely that he would be assigned to be the judge on any of the remaining cases.
No.
Yeah. Just so we can avoid, the appearance of impropriety. Right? We don't want to further undermine the public's confidence in the judicial system, so we won't have a repeat of this trial. So they likely will not assign him any other of the defendants on this indictment. But yeah, can we talk about Trump? JD Vance is his running mate. Son of a bitch, be more shorty.
I don't want to really go to talk about that.
Hold on. Be more shorty just posted that Donald Trump has selected JD Vance as his running mate. That's crazy.
Yeah, I saw that. Earlier, and he was announcing.
I was golfing, y'all, so I'm late. Okay,
so the case will resume probably tomorrow with a different judge.
I don't think it's going to resume that fast, though. I think she's going. Yeah, I know she's going to
have to do some housekeeping, some scheduling orders, So how many witnesses you got left? And we're not about to have a couple hundred more witnesses. That conversation needs to be had. She needs to assess how much more this jury can take. Right?
Didn't I say that, Dennis? I said Glanville from the beginning, that whole year leading up to this, that the system of organization should have been put in place. He should have cut the fat where it needed to be cut. There was no fat.
He should have done that. That was his courtroom management is terrible. It really is terrible. Terrible.
The advantage he has as a chief judge, he didn't have to take no cases. He reassigned most of his docket to Judge what's the judge that ruled in earlier in the Trump case. They had the case before it actually got indicted by
the white judge.
Yeah.
Here's the thing, now, Dennis. This is true
Judge Bernie has most of his cases.
This is also true for district attorneys. They don't have to take any cases. However, they can select which cases that they want to take, and usually they take the high-profile cases. Right. Because guess what? They still have to show the public, their voters, that they are actively still participating in the judicial system, and they should have confidence in them. So they get to pick it, and they throw it to the side, but they always are going to pick the one that is the most high profile.
So what do you think is going to happen with Judge Glanville's career, with everything that's happened, and the spotlight's been on him?
Nothing's going to happen to his career. Nothing. Not one single damn thing. Nothing. There will be no. I mean, in terms of what? Like he's retire. He doesn't have to retire.
Yeah, he don't have to retire.
Well, when we looking at him sideways, like, Judge, you on that BS?
You think he cared? You know how long people have been looking at him sideways? How many months has this trial been going on? I was looking at him sideways when he had a lawyer write an fucking essay or whatever. I would have been like, it ain't happening. I'm not writing anything. We can go to Supreme Court now. Let's do that now, because I don't have time for that. I'm focusing on somebody's life right now. These guys are facing charges that include murder. And you want me to take time away from that? You want me to take my attention away from that to write an essay? And you have the audacity to tell me I can't use the people that work in my office, my paralegal or my secretary. I got to be the one to write. I don't have time for that. So it's not happening. You're going to put me in jail? Hold me in contempt? Because that requires a hearing. And so I don't know why they let him push them around. I would have been like, it's not going to happen, Judge. It's not. It's not. I offer this court my apology. I have nothing more than that.
And that's when that power and that ego comes into play.
Yes, it does.
I tell people when you're in a heated argument in the court, egos, adrenaline always mix, and it makes for a disaster because you don't think about how stupid some things that you're going to say sounds when it comes out. You just know that you feel like you need to say it and you need to hold your nuts on certain things. And now you're going to go back a week or so later like, dang, I shouldn't have did that. But you can't undo that. Yeah. You can't undo it.
Look, I would have bought the lunch. I don't mind, that's little shit. Okay, all right, Judge, you got that. I bought it, but I'm not writing 25 APA stuff. Look. Not unless I chat GPT. Hold on. Chat GPT, write that for I don't have no. And I know Judge he don't care, but I don't care either. See, that's what I'm saying. It's like I know, but Dennis does not want to talk about Trump's case. So when we get off of here, I'm going to jump back on my page and we're going to talk about Trump's case. So
can we talk about? Hold on. Can we talk about Lil Woody though? Lil Woody and his.
Yeah, let's talk about Lil Woody. Let's talk about let's talk about Kayla Bumpus and her media run that she's doing.
Yes.
Let's talk about all the people that came out, started doing interviews once that those motions were filed.
I'm not interested in talking about those things, so I'm gonna let y'all get at it because I love you. And I want to talk about other shit because YSL is not the only trial on the docket.
Okay, we have an 8:00 on the Trump. We have something scheduled at 8:00.
Oh no, we don't because we did this. What you mean?
No, I need you back. We'll talk about that offline.
Bullshit.
That's why I wanted to talk to you about that at 8:00. We have some things to talk about on Trump. A whole list of things. But if you want to leave us,
I never want to leave y'all. Because I love you. I really do.
I know you do.
But I got to go. I
wish I had
to do some other things. If you want to do something later on at 8, we could do that. If we want to back it up to 8 and talk about Trump.
Yes,
I also want to talk about 2020 Project 2025. I'll let you guys know. I'm going to be on the comedian Godfrey show tomorrow. So look out for me there.
Godfrey. I like Godfrey.
Yeah.
And for those guys, for those who don't know, I was taping on the weekend for a show, a very big show starring the lovely Jessica White. I was one of the celebrity judges, and we'll be dropping some clips on that sometime today. You can also go to the Jasmine brand because I think they got the exclusive in page 6. We'll be talking about it as well. So it's pretty dope. All
right, I'll see y'all at 8, family.
Okay, let's go.
Unless Dennis is lying, and then if he is, it's his fault. And I think he owed me $5. So
hold on. Thelma, do you owe some money, Thelma?
I do not.
Thelma, don't you owe some money?
Here's the thing: I won't ask you for my $50 when the Supreme Court recuses family Willis, because you know that's gonna happen, right? It's gonna happen.
It's not a real place at this moment. Atlanta
Clearly,
is not a real place,
so unserious. This place is.
It's not a real place.
It's unbelievable. Like I don't understand. All right, I'm out. I'll talk to y'all later. Peace out.
All right.
Send me your cash. I'm gonna send you a request. Go ahead. Okay, Thelma. So, your thoughts about the interviews that everyone's been doing, particularly Attorney Bumpus, and that it really doesn't matter now because the judge is recused. So does it really matter? It's a mute? As the Judge Krause said, it's a moot issue. So
for her. So here is the issue that I want people to pay attention to. When you have a live witness that is still under oath, it has not been removed from the order of the court. And you go out and you start speaking in the public about information that is surrounding this case, your case, and you set up on that stand and pretended to be special ed, and you
we lost you, Thelma, but I think what you were going to say, if you pretend to be special ed, but you're giving these interviews like you have some college behind you, that's going to call into question the authenticity of your testimony. And they're going to compare your post testimony on direct with your prior interrogation videos and your testimony that obviously was viewed by many that maybe you're not as quote unquote slow as you pretend to be. Because I caught a few things in your interviews that made me feel like you're probably one of the more smarter guys that is on trial. Not on trial, but in giving testimony. Thelma, you must leave and come back in. Right. Stay out of the streets and trouble will not find you. I totally agree with that. Delma, go in and come back. Let me send you a text. I don't know if you think you're still there, but you're really not there. You're black. Okay, hold on. Hold on, she sent me a text. Let's see. Hold on, guys. Okay. Just sent her a text. So I think no, we won't do that. She's coming back in. But I think that Lil Woody, and I was told over the weekend that he deleted some of his or all his videos. So that may be an issue as well, because I'm sure that a lot of that stuff was captured. And if it's not captured, then they have him doing interviews on other platforms. I wouldn't touch him right now because he's a witness in the case. He's a witness in the case, and he's still sworn in. Because Judge Glanville's removed doesn't mean that another judge could not view what he's been doing as problematic for either the state or the defense. So I would, always err on the side of caution. And typically, when you do stuff like that, that inspires judges to issue gag orders for the lawyers and witnesses, and the rule of sequestration is put in place, meaning the witnesses can't talk about anything related to the trial until it's over. And you heard even with Judge Glanville, he told every witness coming on off the stand, you can't discuss this case with anyone. He said that this is one of the announcements he always makes to the witnesses as they leave. Yeah, so they still get right. I agree with you, TB21. They still can pull the videos. They can do a bunch of things. And I would guess that the social media department and the prosecution office has already pulled videos. They're not waiting to go to the link. They're going to be pulling links already. They're going through all this. Now, do I think they should move forward with this case? I think it's just bad. I think it's just bad. I interviewed the former prosecutor, Paul Howard, early on. This was during the campaign season when he was running for re-election. He said pretty much that they didn't have a strong case to prosecute Young Thug. So my question is, what has happened then that changed and made the new prosecutor want to prosecute him? Because Paul Howard and his team of really qualified prosecutors didn't find a strong enough case to prosecute him. But for some reason, this case was prosecuted. And I don't know if DA Fonnie Willis is going to risk using these resources to go ahead with this case when you have a whole backlog of cases waiting to go in front of these judges. So this is going to be very interesting. Very interesting. What do you guys think about Judge Krause? Do you think Judge Krause was providing cover to Judge Glanville? And if so, how would you view her handling any of these defendants in another case? It's pretty tricky. Being an attorney should have advised Woody. Okay. So Petty Patty said, Kayla, being an attorney, should have advised Woody to stay off social media. Kayla needs to get off herself. Well, I don't know. I think that train has already left the station. She's interviewing the lawyers. I don't think lawyers should be doing interviews right now. How about that? Defense attorneys should not really be doing interviews right now, because that can be viewed negatively with the jurors. I know they're told not to watch social media and so forth, but they also might ask, why is one attorney doing interviews and other attorneys are not? If you don't have Shaw, Brian Still, well, we did hear Bruce Harvey doing an interview. He did an interview right afterwards. After the judge referred it to another judge. I don't think lawyers should be doing any interviews until they see where this case is going. Because at the end of the day, they still have clients that they are responsible for, and their life is hanging in the wings. So I don't know. It's kind of tricky. I don't know. I'm not. People probably wonder why I haven't interviewed none of these people. I'm not really interested. I want to see how this case comes along. I don't want to interview potential witnesses. I don't want to interview lawyers involved in the case. And I really don't. Maybe the family members, that may be a public interest. The family members, yes, they may have a story to tell. You may want to humanize some of these defendants, and maybe if someone reached out to me, that is, I don't know if even the victims at this point, we have an active trial, so but it's real tricky. And the other thing, you don't want to be called as a witness. While reporters are typically not called as witnesses because of the reporter shield rights laws in Georgia, you don't risk yourself in doing. You don't risk the integrity of what you do by rushing to interview anyone and everyone you can interview relating to a case that the people are potentially facing life. Not doing it. Oh my goodness. I don't know, Miss HLS. I don't know why, but it's interesting. It's interesting to watch. Let's see how this play out. There will probably be. This has to be assigned. I agree. It has to be assigned to a judge, and the judge is going to have to look at everything. And the judge is probably watching it. And the judge probably said, I never wanted this case. That judge probably never wanted this case. She probably thought it was she probably said to herself, Judge, you can probably say, I don't want this case. I'm glad I'm not on this case. But now she got the case. She has the case, and she has to look at that. Let's see. Queen Black said, I think, Queen Black said, essentially, I think Love convinced finally she could win it. Prosecutors seem frantic, starting with opening statements. Yeah. However, listen, the way you start is not necessarily the way you're going to end. The way you start is not necessarily the way you're going to end. And I think that if they're being honest with themselves, they will probably say, no, we're not going to redo this case. Let's move it along. I mean, they're offering ridiculous plea deals to the other defendants that have been severed. So that's another problem because they're not taking plea deals because the plea deals are life. They're offering deals that they know they're not going to take. So I don't know how this is going to play out. I really don't. I think that what's going to eventually happen is hopefully Judge Ingram gives this man a bond. They have to redo all this. Hopefully he gives this man a bond. All the defendants that are able to post bond, they should be able to fight their case from the street unless they are a threat to the community. Doug was on tour. He was doing music. I don't see him a threat to the community right now. I don't see that. I don't see that. Because the state proffered that Gunner was a threat. Gunner's out here working. He's on house arrest. Let the guy work. Put an ankle monitor on him. Take his passport. He can make enough money to pay his attorneys by staying in the country. Just give him the ability to be able to pay his team. That's all. I think that was the first mistake. That was the first mistake by the judge, constantly denying bond to the defendants. I don't think the prosecutors, and the question is, how do I think the prosecutors did by presenting their case? I think the prosecutors were doing too much, in that they were calling witnesses that really didn't really matter. Like they called someone that used to work at Hertz. The jurors are probably not going to remember that. I remember that because I saw it to be so insignificant. They brought a guy in who was in a wheelchair, who you guys didn't see that he was in a wheelchair, but he was in a wheelchair and he really couldn't offer too much. And if you guys remember in the very beginning, there was a lot of talk about weed, small drug sales, nickel dime bags. It looked so weak that I was looking for the big money. I didn't see that. I didn't see that. I saw a lot of repetitive testimony, cumulative testimony that probably they could have did better with bringing in fresh witnesses. Because if you start out, you're going to start out with your strongest witnesses. You don't want to bore the jury. You want to keep the jury. The key is to keep the jury attention. And you don't know these 12 people. You don't know what their lives are about. And they're now sitting home wondering what's happening. They probably know. Between you and I think these jurors are watching what's happening. They want to know why these delays are delays. I do not think they're removed if they have family members that can tell them, hey, Mom, that case that you on, they got rid of the judge. No, come on. This is social media. This is 2024. People are on social media more than they're on the regular TV, on the regular programs. So I do see that this case will likely be derailed because there's so much negative press that came out of it. And I don't think any judge wants to be a part of something that's going to put a stain on their career by handling this case. I don't think so. I don't see that happening. I don't see it happening. I really don't. I don't see it happening, but I could be wrong. Be honest with you, I didn't think the judge was going to get recused. Let's see. Hold on. Shaw B, what did you say, Shaw B? Do you think DA Love will go on YouTube? Do you think she's going to get removed from the case? How do you think this thing's going to look? Because the judge's ruling didn't slam the prosecution. It was focusing on the judge. It didn't slam the prosecution. And that says a lot. And she basically accused Brian Steele of embellishing on what really happened. So I don't know. We'll see. We'll see what happens. I'm gonna be a part of this next case too. I'm gonna file into the case. We will see. I want to be the day one when that judge takes the bench. And she's gonna look at all the media and she's gonna say, hey, you lady over there, you've been running your mouth a lot over there. Yeah, you part of the media. I'm watching you. I know what you said about Judge Glanville, but I'm watching you. This may end a little differently. We'll see. I'm not going to tell you what I'm talking about. We're going to watch and see. Now, DA Love, she told me. DA Love told me, she said, we're not allowed to watch YouTube. We're focused on the case, so we're not really allowed to watch YouTube. How do you look at the evidence? Who pulls the evidence? Yeah, you got people in the research team. I don't know. I'm gonna take it for what she, I'm gonna take it for what she said. I'm not gonna doubt, that. So you don't think she'll come to YouTube? I think she'll come to YouTube at some point. She needs to do some interviews. Well, not right now, because it doesn't look like she's winning right now. Hold on, let me see. Guys, stand by. Let me see if my co-host is coming back. Hold on. Stand by. She had an issue with a device, so I don't think she's coming back. Yeah, that part, Patty. I think she's going to control her courtroom a little tighter, but we'll see. We'll see. Her name is trending on the internet now. Judge Ingram is trending. What be more shorty? Who you talking about? Who you talking about? Be more shorty. Who you talking about? Which one? Put a name on it. Put a name on it. Be more shorty. Put a name on it. Hold on, guys. I want to share something with you. I need to share something with you guys. Hold on. Let's see if I can share it from this phone here. Oh my goodness. Hold on. Stand by. See if I can pull this up here. Trying to share this with you guys. Let's see if we can share this with you guys real quick here. Do I foresee a mistrial? What I foresee is a mistrial. I do. Actually, I do foresee a mistrial. I think what's happened thus far is just bad to move forward. They got to call it. They got to say, listen. The judge has to say, listen. There was too much damage done, and I'm not entertaining this crap. We're not doing it. You had the opportunity to get it right. You didn't get it right, and she may not want to deal with this. But again, this is the judge's call. She might decide that she can handle this. I don't know. But again, you got to remember, Judge Glanville's still in the building. So, and we did learn just from this judge's ruling that she wasn't trying to be heavy-handed with Judge Glanville. She was not trying to do that. So I'm just wondering how that's going to play out. Really wondering how that's going to play out. But I'll be in the courtroom. I want to show you guys something. I'm just trying to upload it. Special treat, special treat, special treat. You guys stand by, stand by. Let me give you something. I'm trying to pull something up for you guys. Special treat. I was going to save it. I guess I can share with you guys. I can share a little bit with you. Here we go. I see you. Here we go.
I'm sorry, I think it's just like a little bit
It's AJ Young. I am gonna be the next bombshell.
What's up, y'all? My name is JoJo. I'm from Detroit, and I am here today at the Bombshell Academy to come show them what a real bombshell looks like.
I feel like 83 by the D's. Oh. I snap, crack, and pop. I got my own soundtrack.
And here's my thing. I understand that you're emotional. I get it. Emotions they run high. But I've had to work literally and bury people, and nobody cared about the reason why I was crying. I need you to do your job first and then explain to me why you're crying, because I'm totally here to hear about it and understand and empathize with you. But I can't do it if you can't do your job. Now go back out the door and come back and do it again. No tears and then cry later.
That's right, Judge.
That's how you get a bombshell.
My name is Zahaya. I am 17 years old, and I am a bombshell because I'm 17 and I handle my own business. I'm a bombshell because I'm 46 years old, and
I want to show people my age and older that they can still follow their dreams at any age, and just encourage people to keep going and to just chase after their passions.
Can we get a tissue? Words are just words, you know. At the end of the day, you have to look in the mirror and believe in you. And if you believe in you, everybody else will too.
I see it, yeah, I see it. As long as you see me at the casting and not on the news, it's working.
Oh, that's right, baby. Thank you. Thank you. By the way. I'm Natalia Good, and I'm from Myrtle Beach, South Carolina. So I actually graduated from high school 6 months early. I currently get to work with California Sea Lions, and every day I am out there 8 hours a day working for those animals, just to be an advocate for them and their species out in the wild. And
okay, guys, that was a special treat. I don't want to give you too much, but yes, I'm one of the celebrity judges on upcoming project with the supermodel Jessica White. We had a fun time. Yes, that was Cliff, celebrity hairstylist. Also, we have Fiscani, celebrity fashion stylist, and we have the lovely Jessica White. So yeah, this is just a little teaser. I didn't show you too much of it right now, but I've been working. I'm actually be flying to LA. I'm working on another project as well. But you guys got it first. That is the exclusive. You guys got it first. So I don't know if it dropped anywhere else, but you got it first. Yes, that's me. It's me. That's me with the, that's me with the shades on. That's me right there. And I speak a lot, but that clip is just a part of the bigger picture. And I didn't even play the entire clip. I may play it later on, but I want some of the other outlets to run it as well. So it's good. So this is one of the projects that I've been working on. And you guys have seen me last week on Court TV, actually 2-3 episodes. Make sure you go check out Court TV because we are just working. That's it. We're not on. If you don't see me on YouTube, rest assured I'm doing something. I'm not on YouTube all the time, but when I'm on YouTube, I like to have fun with you. So make sure you tell a friend to check out Bombshell Academy. With that said, ladies and gentlemen, I appreciate you. I really do. We should be back tonight around 8 p.m. with the lovely Akeisha El Shabazz and talking about former President Trump, the assassination attempt, and Project 2025. She wants to talk about that, so I'm going to talk about it because she wants to talk about it. I definitely have the PDF. There was over 900 plus pages. I haven't read in the entire 900 something pages. And that's something that you got to just take it slow and read the pages, and then you come back and then read a little more. But it's going to be a fun thing. With that said, I appreciate every one of you, and I will be dropping some more clips on the community wall from the event, the taping. Pretty dope. With that said, I am out. I appreciate all you came in to watch the show. But like everything else, it must eventually come to an end. And with that, we're going to take you out of here. We out. Let's go.